we requested unique dietary restrictions, and for some reason the computer didn't send those through to us, so I apologize for not providing that for you today. Next time we'll be better about that, but I apologize to those who are technical like that. So we're going to go ahead and get started. Just so you are aware, we are recording this. There are some people in St. George and Logan who will be watching this. So I guess if you want to be on camera, you can be on camera. But it is being recorded. I am Emily Lee. I'm the administrator of the George training program. I used to be Emily Sorensen up until 2 months ago, so if you were confused why there are two different Emily's emailing me, that is why my name changed in the last couple of years. But we are going to get started. The handout you got today has the agenda for today. We'll go through that. Yesterday I emailed all of you the new lawyer manual. I didn't print those out. If you did not get that email from me, send me an email today and I'll make sure you get that. But that manual, I'll reference it a few times today, and it has frequently asked questions, it has some resources, and a lot of the forms that we'll be talking about today. We'll just go through the agenda. Well, first, I have Judge Chin from the Holiday Justice Court, who is a fantastic mentor and a great advocate, a former bar president, and he's going to talk to us a little about the value of mentoring in the program and what you can get out of it. And then you are lucky enough to hear from me for about a half an hour about the program and what you're doing here and what is expected. So we will go to that point.
Thank you. I realize it's the lunch hour, and while I'm inclined to speak for as long as the 20 minutes allotted, I welcome the opportunity to entertain any questions or concerns you may have. The mentoring program is not even a decade old at this point. It got approved by the Supreme Court back in 2008. Colleague who was on the Bar Commission as we were exploring the practice of law, who was determined through the Bar Commission and in discussion with the court that this type of program was well suited to assist new lawyers who had been admitted to the bar and were entering the bar as we were a growing bar. I think back then we were, Christian, 8,000-9,000 thereabouts, members of the bar, and we were growing. So we felt that there was a need to have a program that assisted new lawyers admitted to the bar with a transition from the world of academia, law school, which prepares you in a limited fashion for the practice of law to deal with that transition and the various nuances. So when Emily, Mrs. Lee, asked me to share some thoughts, I was particularly thrilled because I remember that when we first looked at it, there were some apprehensions by various individuals that it's more taxing for them. Not necessarily the mentors, but possibly even the mentees. Those who will be mentored would have additional requirements, having just gone through the bar exam, having been duly admitted. Now you're placing these additional requirements. But it's not intended, and was not intended to be onerous. It's intended to facilitate a good professional transition. The things that we were taught in law school certainly has its application, but its application is somewhat limited. So as I explored what I would share with you are the values of the mentoring program, I'd like to start by, when you get your manual, take a look at page 4 of the mentor manual, and it identifies some of the program goals, which it states as follows. To train new lawyers in their first year of practice in professionalism, ethics, civility, to assist new lawyers in developing the practical skills and judgment necessary to the effective practice of law, and to impart to all new attorneys the importance of organized mentoring. So that's an interesting list of goals. And back then, as there is that ongoing concern, is the direction where the practice of law was going by virtue of the media, television, as with respect to civility, professionalism, and the perception that lawyers were not being terribly ethical. But beyond those goals, there's much more to mentoring. For those who have that opportunity, I would say that it provides you a certain self-satisfaction, and it provides you the opportunity to give back, especially if you truly enjoy the practice of law. And I say that because if you are miserable in the practice of law, and there's some who are, quite honestly, mentoring is not your starting point. Get situated, because you're trying to help a new lawyer transitioning into the practice. And if you are just sharing your miseries, how is that going to encourage them? How is that going to develop those essential skill sets they need to fulfill the goals, the program goals? As it said, to develop practical skills and judgment necessary for the effective practice of law. So I would suggest to you that if you have your qualms about the practice, you certainly can share them. I think it's only fair that you share them, but do them in a way as to not discourage these new lawyers. I'm often discouraged by the fact that when I run into attorneys and with their children, there's an introduction, they'll often jokingly say, I discourage them from entering the practice of law. But they've been in practice for 20, 30, 40 years. I have to say, I'm thrilled my son decided to go to law school and is about to engage in the practice of law. I thoroughly enjoyed it. So one of the primary values, in my opinion, of mentoring is mutual self-improvement and professional development. As you reflect on what you share and you assist these new lawyers, and for the new lawyers, as they have their concerns or apprehensions about what they're doing, where they're heading, because even if you're in transactional area, you're in the criminal arena, family law, I was just meeting with Mr. Peterson, visiting briefly, that does not mean, or that's not an indicator, that's where you end up. I started off initially as a law clerk bailiff, retired mentally, transitioned to a full-time law clerk. Then I transitioned into criminal prosecution as a city prosecutor, then a county prosecutor, then I went into defense, and then I took the bench. So over the career, depending where you are, you may find yourself in different areas, and that will add to that dynamic of whether or not you can say you are vested in one set area without any reservation, or could you go through the whole arena of the areas. When I talk about mutual self-improvement, it also gives you, as a mentor, a moment to reflect on how you got to where you are. Now, for those mentors here present, just by virtue of a show of hands, how many have been in practice for at least 7+ years? How many at least 5? Anyone? Most of you are under 5? Is that, I see one head nod, but no hands raised. Those over 10. Okay, so help me understand my audience then. Give me an idea, if you don't mind, how long have you been in practice?
What time is it?
It's approximately 12:10 today. So even if you're under a 5-year, I will tell you the time flies much more quickly than you anticipate.
I was under the impression we were all new lawyers, that in fact, in less than a year, we're mentees.
You're mentees. Thank you. I apologize. You can tell that I didn't read that memo. But let me share with you that as mentees, because I thought some of you looked rather young. So lovely. So then my approach is still the same, because I thought mentors, there was one mentor here with his mentees, so I thought there were several mentors here. I knew some of you were mentees. So most, because you've been at 5?
I've been at 5 months. Yeah.
5 months? I thought it was 5 years. So that's where you learn, even those of us on the bench are not infallible. That we make errors all the time. We try to correct them. So for you as mentees, those entering the program, share with me, if you have any questions, your expectations. But this is for you, because I'll take it from that other vantage point. The professional development that you'll get as you select your mentors. You've all selected your mentors, is that fair to say? There are certain things I would suggest that you are open with them. If you have reservations, and this goes back to my initial statement, if the mentor, himself or herself, is being a little overly negative, hit the pause button and have them share with you why they are still there, having started the practice for such a good time. Because occasionally, as human beings, we all have our miserable days. And there are days you just want to pack it in and either go rafting down Green River, whatever that river is that has the rapids, or you may want to go hiking and climbing the mountains. If you need that mental break, and you have the opportunity to take it, the stresses from the practice of law will absolutely drive you crazy to where, if you fail to try and figure out what you're doing and where you're heading, I will guarantee you that within your first 3 years, your name will appear in that rather colorful section of the infamous Utah Bar Journal with a discipline. So discuss with your mentor some of your concerns. Part of that also self-improvement is also to give you an understanding to not second guess your ability. If you survive law school, you survive the bar exam, and you survive the admission ceremony where you sit there for an inordinate period of time before you fully take the oath of an attorney, you will survive the practice of law for a lifetime. You've met those 3 initial threshold requirements. But in terms of your professional development, how many of you are certain as to which area of practice has your principal interest? By show of hands. A fair number. Test the waters. Really test the waters. When I left law school, and I started with Judge Medley, first as his law clerk bailiff, little did I realize the experience would be so invaluable, because I got an opportunity in terms of how my professional development to interact with members of a jury for over a 2-year period, even as his full-time law clerk, that provided me with a unique insight that I utilized when I was a prosecutor and a defense attorney in every jury trial I conducted for those umpteen years. Because there's certain things that you will learn and that you add to your tools to be used at the given time in your area of practice. That professional development you'll get is so unique that if you were on your own without a mentor or someone to give you that extra guidance, you might find that you missed something important as well. So use that opportunity and not limit yourself. Because that. The other value I would suggest, to make sure I don't exceed my time, is the wisdom. You gain, as I said, an insight. That insight that you gain is not just from the experience of your mentor, but hopefully as you interact with each other and with others in the profession, you'll get a sense as to what you wish to do for the duration of your career. How you wish to be received and perceived. Oftentimes, it is perceived that lawyers are ambulance chasing. I think that's misconstrued. And I remember years ago when we were in law school, Dean Teitelbaum, the Student Bar Association at the U of U, designed a T-shirt for one of our activities. It was ambulance chasers, and he was not pleased. A cartoon ambulance chasers. So we're always chasing after things. Not true, but it's up to you to have the wisdom and develop this sort of reputation to dispel that. And I'll share with you, even though we're now, is it 14 or 15,000 in membership? Is that fair to say, Christian? We're still a small enough body that if you fail to maintain the degree of professionalism and civility, as is one of the goals, or abide by the ethical rules, that reputation, before you even leave the district court, the 3rd division, it will be in the 5th division before the end of the month, if you make an appearance. It follows you. So develop the wisdom to know what you don't want to follow you, and to develop what I would say is a solid reputation. Because when you have a solid reputation, and you appear before the judge, he or she will accept your representation without any hesitation. To this day, I have people who appear for me. I had someone this morning, I had a criminal calendar. And I have reservations if this individual were to make certain representations. So I have corroboration from the prosecutor before I accept. And that's not the reputation you want. So that's one of the important skill sets that you should try and develop, is to build a good reputation. Another value to the mentoring process is it helps you develop what I would say is that level of competence where you feel comfortable in, if you're going to be a trial attorney in that trial setting. Your first appearance before a judge is always nerve-wracking. Judge Hilda, who passed away, for example, my very first trial as a city prosecutor, he ruled against me and decided in favor of the other side. And I can remember distinctly what Judge Hilda said to me. And Judge Hilda said, "Mr. Chim, you had a good case, but I ruled the way I did so that you will learn from this experience while it's early in your career, so that you don't repeat it to your detriment." It was a traffic trial, so it was nothing major, but it was significant enough that he mentored me in that fashion to pay attention to the details as I conducted a trial. Fortunately, it was a bench trial. And from that day forward, I never forgot the one particular item that resulted in the acquittal of the individual violator. Never, from that day forward. So use those opportunities and add them to your tools as well. The level of competence comes over time. Even seasoned attorneys, and you can talk to your mentor about it. Even your mentors will have their off day. As I said, everyone has an off day. Judges also have an off day. And there are times that we need to step back and take a deep breath before we continue to make sure that we're not adding to the woes of the parties before us. Similarly, for new laws, you don't want to add to the woes of your client by being unprepared. So in the process of developing competence, you learn the skills to be always prepared. Now, will you be 100% prepared? I don't think in the practice of law you can ever be 100% prepared, because the moment you over-prepare, something comes in that you've never thought of. So your preparation should be to the best possible extent you can under those circumstances, and be open and flexible as well. So that's one of the values that you have from that mentoring process as you discuss with your mentor and as you engage in that practice. Another one that I noted is the career guidance you get. When I started with Judge Mendel, I thought I wanted to do death penalty defense. I was so taken by the whole notion of death penalty defense. And during my tenure with him, we had a couple death penalty type cases. One of my colleagues was a law clerk bailiff as well to the then presiding judge of the 3rd District, also did death penalty cases as well. And we would often discuss some of the nuances. And the learning tools that you develop are so wonderful from that area that you can then decide and have a sense, do I really want to go into this area? And within 6 months, I changed my mind. I did not want to do that penalty defense anymore because it can be so emotionally cruel. Even with the individual, and you're providing them the constitutional defense, as you look at the full case and the workflow, it was so taxing as I observed some of the cases as they were going to trial, that I then realized it would drive me bonkers by the time you get that death penalty defense that takes sometimes between 3, 5, 7, or 10 years, because they're on death row for that extended period of time. So it gives you that career guidance, and discuss with your mentor, even if he or she is in a particular area. The whole program is not to expose you to a variety of different practice areas. Use that to your advantage. I have an attorney who I'm mentoring at the moment who is in a trial practice, a general practice, and she'd never gone into a juvenile setting, and so that's one of the things we discussed. And she thoroughly enjoyed experiencing what happens in juvenile court, and then other areas that you branch into and that you're exposed to will give you that ability to truly decide where you wish to be 5 years from now, 10 years from now, because as I said, it goes by quickly. It really does. And I will also suggest it gives you an opportunity to have a network in terms of its value that will prove to be ultra beneficial to you as new members of the bar. Not just through your mentor, because you'll have that, hopefully you'll have that career-long relationship, and even lifelong relationship. I also think that the way it's designed, the mentoring program allows you to establish a relationship that's kind of familial. You can consider it in a legal familial sense. Doesn't mean you need to share your deepest, innermost thoughts, but you can share your deepest, innermost concerns with your mentor as well. I view it in terms, in that sense, as a little bit of a social work psychologist opportunity, because on the day you have a motion or a hearing, do I have 2 minutes? The day you have a hearing that you have been told to prepare for, and you're defending it, or you're arguing it, and you're stressed, or your mentor. Sound on. Your mentor is there as a sounding board as well. And so let me, in wrapping up, since I have rambled, are there any questions from anyone here? Please.
I'm dying to know what the technicality was that you lost on your first trip.
Oh, you are. I'll tell you what it was. I failed to establish the venue. That's one thing. It happened down the street. It was in Salt Lake, but I failed to establish in the city of Salt Lake City, or the corporate limits of Salt Lake City. That's one time, and that's what he said, Mr. Chair. You forgot to say the venue. You forgot to say in the corporate limits of Salt Lake City, therefore I must dismiss. So yes, it was one of those. Not the question I anticipated, but nonetheless. So let me, in conclusion, suggest to you that the primary value of the whole program is not just to achieve those goals, but to make sure that 20 years from now, you'll be up here, or even 10 or 7, engaged in the practice of law, enjoying the practice of law, without having been one of those individuals in that section of the bar journal, fully vested in the profession, this noble profession. And in conclusion, let me just share with you a thought that I have. In terms of good mentors, a good mentor, and this applies on both sides, guides and trains. A great mentor nurtures, encourages, guides, and trains. Make sure your mentor is nurturing. Doesn't mean they'll take you to lunch and make sure you're properly hydrating your knowledge. Nurture you in the profession. I wish you well. Welcome to this profession. And one last bit of encouragement, be engaged in the bar. Be an active member of the bar. As members of the Young Lawyers Division, be actively engaged. And someday, when the time is right, become a member of the Bar Commission and seek also the opportunity to be part of that bar cabinet. Good luck to you all. Thank you.
Hi everyone, we're going to do a quick change on the agenda due to my scheduling conflict. I'm Kim Holding with the Utah Bar Foundation, and I want to talk to you briefly about client trust accounts. It's something that you probably don't care about until you care about it, and then when you care about it, you'll care about it a lot. So let me talk to you a little bit about what is the Utah Bar Foundation. The Utah Bar Foundation is a totally separate 501c3 entity from the Utah State Bar. We were founded in 1963 as a charitable organization that provides funding to law-related education, legal services for the poor and disabled, and other worthwhile law-related projects. Hence the Scott Matheson statue that you see at the Madison Courthouse. Yep, we helped fund that. I suppose that's a worthwhile law-related project, but there you go. We are governed by a 7-member attorney-based board. Judge Chin actually is one of our past board members. You have to be active in Utah, licensed in good standing, so again, not in the blue disciplinary section of the Utah Bar Journal, which is, quite frankly, a lot of fun to read. And probably the most read section of the Utah Bar Journal. If you ever have interest in joining our board, you can contact us. Let me tell you, and I'm going to repeat this a few times, our website is utahbarfoundation.org. utahbarfoundation.org, not Utah Bar. So when you are looking for things about client trust accounts, you will go to utahbarfoundation.org. So let's talk a little bit about IOLTA. IOLTA stands for Interest on Lawyers' Trust Accounts. The program was created in 1983 and adopted by the Utah Supreme Court. What exactly is IOLTA? Well, back in the late 70s, early 80s, you would open your client trust account and the bank would earn all of the interest on your client's money. In Utah, depending on interest rates, that accounts for anywhere from a few $100,000 to $1 million a year. And in the early 80s, there was a Supreme Court justice actually in Florida who said, we can put this money to really good use in helping legal services for the poor. So he created the first IOLTA program in Florida. In 1983, it was adopted here in Utah. What this means for you is it is mandatory for you to put your client's funds in an interest-bearing account. You can have one of two account types. Either an IOLTA account, where the interest comes to the Utah Bar Foundation and it's a pooled client trust account, or if you have the type of law practice where you are handling large sums of funds for your clients, and they can earn their own interest on that money, then you would put it in a separate interest-bearing account for the client. I will tell you right now, where financial institutions are paying typically 1/10 of 1% on interest, you need to be holding a lot of money for a long period of time, because if you walk in and say, hey, I have a $10,000 check that I'm gonna hold for my client for 2 months and I need to earn interest on it, they're gonna shake their head and say, our bank fees, you'll actually be paying our bank fees, the interest won't even cover that. If you ever have questions on that, again, get in touch with me at utahbarfoundation.org and we can help guide you with that. Now, the other thing that you need to be aware of is with your licensing form. There is an IOLTA section of your licensing form. You might be thinking, I'm a corporate attorney, I'm a public defender, do I need a client trust account? You only need a client trust account if you handle client funds. So if you are a corporate counsel, if you teach at the law school, if you are a government attorney, you don't need to have a client trust account. But if you hold or handle client funds, then you need one. If you have questions on should this be held in a client trust account, feel free to contact us or the Office of Professional Conduct. They have an ethics hotline. Now, on your licensing form, you will need to certify each year that you are in compliance with the IOLTA rules. If you ever want to have a fascinating read, you can find the IOLTA rules as well as the client trust account rules on our website. They're about as clear as mud, and they're great if you're having trouble sleeping. But you can find those, and you will certify that either you have an IOLTA account and you provide us with the information. Now you will, after this first go around, you will always license online, and so we pre-populate that information that we have on file. So if you moved firms and you've never updated that information with us, we will have your old firm's information. So you'll just go in, change the information, make sure it's correct, certify that it's true. If you don't have a client trust account, you will certify that you are in compliance because you don't handle client funds. Now, the one tricky phone call that we get fairly frequently is, I am licensed in a couple of states. My main practice is in Nevada, for instance. However, I handle Utah clients. Do I need to have a Utah client trust account? Well, the way the rules read, you either need to have a Utah client trust account to hold your Utah funds, or you need to have your Utah client's permission to hold their funds out of state at, for instance, the Bank of Nevada. A lot of people accomplish that by putting that in their retainer agreement. Again, these are pretty detailed questions, so if you have questions on these things, feel free to call me. We do have an approved list of financial institutions where you can bank. That's not because we want to limit you, it's because the financial institutions have said we do not want to handle IOLTA accounts. So it's most of the big financial institutions that you will think of, Chase, US Bank, Wells Fargo, Zions, all of those types of places, as well as a handful of credit unions. You need to know that your client's funds are insured up to $250,000 per client. So if you were banking at, I'll be ridiculous and say Chase Bank, and they folded and went out of business, your client funds would be insured up to $250,000 per client. You need to care about that, again, if you're handling large sums of funds, or if your client also personally banks there and you're doing large transactions. This happens a lot with real estate transactions, different things like that. I do get a question more frequently than I used to that I will address now, especially with you as new lawyers. They say, I work for a big firm, I have no idea of what the client trust account is, I don't handle client funds, I don't know. You need to find out. That's information you need to have. Unless you are paid a straight salary by the firm and your salary is not dependent on billable hours, like if they have expectations that you're going to bill 1,800 or 1,600 or God forbid 2,200 hours a year, you need to have that client trust account information on your IOLTA form. If you are paid a straight salary of $75,000 or $300,000, whatever a year, and it doesn't matter if you work for 1 hour or 2,400, then you don't need to have that information. We are seeing more law firms contracting with newer attorneys for a straight salary, and they just give them work. It has nothing to do with billable hours. So if you find yourself in that position, again, and you have questions, feel free to call me, and I would be happy to answer any of those questions for you. Again, if you're setting up an account, some of the financial institutions we work with ask for funny things. This is not our rule, this is their personal. They will say something crazy to you like, we need a letter from the bar saying that you can open your account. We've gotten that enough that we've actually created a letter, and it's on our website at utahbarfoundation.org. They just need it internally, it's not something you have to send to us. When you set up your account, the bank does all of the work. You set up your account, you deposit your client funds in it, the bank computes the interest that is earned on that account, they remit it to the Utah Bar Foundation, they do all of that reporting. Now I will say, keep your eye on your bank statement. Sometimes when people go into the bank, especially if they choose to go to the Zions Bank that's located inside the Dan's grocery store in Pleasant Grove, and they say, I'm an attorney and I need an IOLTA account, you know you should be afraid when the new accounts person says, so you want an Ayatollah account for what? Or they start asking for estate trust documents. That's the other reason that you need to get in touch with us and say, the person I'm talking to doesn't know what we're dealing with. Zions Bank, who is a very large financial institution in Utah and has millions of accounts in Utah, they hold 370 IOLTA accounts. So you can imagine this is not a common account type. So if you have any questions as you're at the financial institution, if you have any questions about your particular situation or instance, please do not hesitate to get in touch with us. Does anyone have any questions now? Oh, there's one other thing I want to mention. What do we do with the interest? We make grants, as I mentioned before, to organizations that fund law-related education and legal services for the poor. So Utah Law-Related Education, Utah Legal Services, Legal Aid Society of Salt Lake, Disability Law Center, and then places that do things like specialty law, like Holy Cross Ministries and Catholic Community Services that help with refugee resettlement, and they're helping those people do their immigration documents to get their permanent citizenship. Different organizations like that. I would encourage you as new lawyers to find out what those resources are, if for no other reason, so that when your neighbor walks next door and says, hey, my sister's cousin is getting a divorce, and they're wondering if you could help them, and you're thinking, I'm a bankruptcy lawyer, I don't know anything about divorce. It gives you a place to refer people as well. And so contacting the Community Legal Center here in Salt Lake and the Southern Community Legal Center in St. George is a great place to be able to refer people. So with that, any questions? Wonderful. We'll get in touch if you do have any. Thank you.
All right. Now the fun part. Oh, come on and laugh. I don't have a sense of humor at all. I just think okay. First thing, on the back of the agenda that I gave you is the deadline for your budget discussion. It starts July 1st and June 30th, 2018. You will see that we are already about halfway through that timeline. June 2nd was the date to select your mentor. There are a few of you in here that still need to tell me who your mentor is. If you need help with that and you get to do that, let me know immediately so that we can make sure the mentors are ready to go by July 1st as well. Then you'll see the next thing that you will be doing is submitting a plan acknowledgement, which I will talk to you about. and that will be due, I didn't change the date, oh, I did change the date, August 4th. So you'll have all of July to meet with your mentor that first time. And then the 2 status reports and the completion certification I will talk about in a minute. So that is your timeline. And I've been doing this for a while now, and it never ceases to amaze me how many phone calls I get on the date something is due saying, oh, this just popped up on my calendar. So you have these from the beginning, these dates. And just like anything else in your practice, you need to plan ahead for these. So put them in your calendar a week or 2 before they're actually due so that you can get them in on time. Okay, Judge Chin went through kind of the history of this program. It started in 2009, and it was a recommendation by the Supreme Court of Utah who discussed a paper written by Justice Scalia, Alan Sullivan, who is a local attorney. They wrote about apprenticeships in the UK and the practice of law here in the United States and things that were lacking between law school and practice. So the Supreme Court commissioned the Bar Commission to research and start this program. And so it started 2009. It was one of a handful of mandatory programs around the country. We kind of took the program that Georgia had created and modified it just a little bit for us. And we were able to grow this program. We won an award from the ABA in 2013 for professionalism because of this program. So it's not, it is unique in the country in that it is one of a handful of mandatory mentoring programs, but legal mentoring is becoming a growing field. And it's meant to transition you from law school to the practice of law. And my little bubbleheads up here, it's a one-on-one personalized CLE. And if you can frame it like that in your mind, hopefully it won't look as much of a checklist as it actually looks on paper. But this is a chance for you to meet with someone who has been practicing, who has been vetted by the Utah State Bar, and to create these little personalized CLEs for an entire year to help you with your practice. So I've given you my PowerPoint slides, obviously. Go through these. Judge Chin brought up the program goals. It's threefold: to train new lawyers in professionalism, ethics, and civility, to develop practical skills and judgment necessary to the practice of law, and then to impart to all Utah attorneys the importance of organizational mentoring. And that first one, I want to touch on a little bit. Because professionalism, civility, and ethics, that's the foundation of this program. That's one of the things that you can read about in a book during law school, and you can read about the huge ethical concerns that happen, like if your client confesses to a murder and what you're supposed to do. What doesn't happen in law school are those daily things that can come across your desk, right? Do I respond immediately to this? What if my client asks me this? What if the opposing client calls me and not his attorney? All of those little tiny things that you can't learn in law school, these are what you have a mentor for. You can call your mentor, you can talk to them. Professionalism especially. How many of you have already had a hostile encounter with opposing counsel? All right, a fair number of you, right? That is something that you can't teach in law school, right? How do you deal with those opposing counsel? How do you keep yourself from being one of those opposing counsel? Last year, we had a new attorney who got himself into kind of a bind and was less than professional with opposing counsel. Fortunately for him, this opposing counsel is a close member of the New Lawyer Training Program Committee. Called us to see if this new lawyer had a mentor and if there was anything that the program could do rather than immediately refer this new lawyer to the Office of Professional Conduct because it merited that. So we talked with the mentor called the new lawyer in, they talked it over, and the new lawyer was able to avoid a bigger problem and was able to handle this. Now, there are circumstances there that are unique. Had the opposing counsel not wanted to deal with this through the program, she didn't have to, but so those are some of the things that this program is meant to do. This is so exciting, isn't it? about a database that has been set up, and I can never remember, the Institute for the Advancement of the American Legal System. And the ABA, together with a few other entities, has done this Foundations for Practice, the Whole Lawyer, and the Character Quotient. And they did this study of 25,000 practitioners across the country, what they thought new lawyers needed for practice, and what were some of those skills they needed in the short term, what were some that needed in the long term. Utah participated in that, and roughly 425 practitioners from Utah contributed. So if you go to the link in the database, you can pull up Utah's unique information. But what I have here are the top 10 skills nationally that come from that database that practitioners think new lawyers need in the short term. And as you can see, none of this has to do with how to file a brief, how to argue a motion, how to get to the courthouse. It's none of those practical things. It is keeping confidentiality, arriving on time, commitments, integrity, diligence, strong work ethic. It's these soft skills that you aren't taught sitting in constitutional law and law school, right? And this is one of the prime examples of the type of things that you can get out of this program if you use it correctly. So the keeping confidentiality, right? When you're talking with your mentor, you're going to come up against a few instances where you're talking about a case and you have to decide, right, where the line is between revealing too much to your mentor and about keeping client confidentiality. You can also discuss those things with your mentor. Responding promptly, you can work those things out there. There are a few times I hear from mentors or new lawyers that the other person in the mentoring relationship isn't getting back to them. So this is a relationship that is, and I hate to use this, but it is a safe space to develop these types of soft skills between you and your mentor. And it is things that practitioners think new lawyers need, but they don't get in law school. And short-term goals for Utah kind of run along the same lines. So it's an interesting read if you pull up that database and look at the information. It's fascinating. Okay, so I'm going to skip ahead really quick because I want to show you this, the checklist, which is your steps to completion. This is like the overview, which follows the timeline a little bit. This is in the manual that I sent you on page 15. So we're already up to here. Your mentors attend mentor training. Then you're going to have your first meeting with your mentor. You'll submit to plan acknowledgement, do 2 progress reports. The new lawyer ethics course happens twice a year, once in April, October, part of that minute, and then 6 required 5 lecture sections of the plan. So the initial meeting, and I know we have one mentor here, and I'm going to kind of call on you if I might. The initial meeting, what is the best thing that a new lawyer can come to that meeting with?
With their manual
Okay.
intact, also to already have an idea of topics they want to discuss with the mentor.
Perfect. Okay, did you all hear that? So to bring your manual and to bring an idea of what you want to discuss with your mentor already. So don't show up, yeah.
But one other thing, please bring your calendar as well, so we can calendar out as much as we can for several months in advance. Lawyers' calendars fill up very fast.
Yes,
So.
thank you for bringing that up. And bring your calendar, because I'm telling you, the earlier that you can schedule these things, the easier it is when you come up against something to get it done. So come with an idea of what you want to talk about with your mentor. You all have the plan in that manual, the full plan. Look through it, determine which sections you want to go over. So come prepared. You can talk about your career history. You can kind of get to know your mentor, because I know there are a lot of you who have never met your mentors before. Come with the goals. As part of your plan acknowledgement, you need to come up with 3 goals for the year, and this is a way to kind of focus your year and to understand what you want to accomplish. Talk about about the mentoring year, your deadline, so bring your calendar. Develop the mentoring plan, which I'll talk about in a second, and establish a schedule. The ground rules is important. Talk with your mentor about when and how you want to contact each other. What you want to talk about, if it's strictly a professional relationship, or if you are more willing to talk about personal issues as well. Some mentors don't like to talk about personal things, they want to keep it very professional. Others will invite you to their Saturday night barbecue. It depends on the relationship that you and your mentor establish. And then agree to have candid discussions. Some of you have asked about your direct supervisors and the reasons that we don't allow you to have your direct supervisor as your mentor, except in certain circumstances. And that is because we want you to be able to be open with your mentor about your work. And it sometimes becomes difficult in the plan acknowledgement. So the mentoring plan, like I said, it's in your manual. That's really tiny writing, but that is a list of all the sections. So there are 6 required sections in this plan that you have to do. They're required. Then you have a number of elective sections, and those are substantive areas of law, and you choose 5 of those to go through during the year. Please remember that your mentor does not have to be in the same area of law in which you practice. This plan is not meant to be a substantive, in-depth discussion of an area of law. It is meant to talk about those required sections, law, office management, the legal community, implicit bias, some of these other general things, and then to help you have exposure to different areas of law. And I know some of you, because I was like this when I went through the program my first year, like, well, I know exactly what kind of practice I want to be in. Why on earth do I need to go talk about other areas of practice? I guarantee you at some point in your life or in your career, your practice will intersect with these other areas of practice. And to have a basic understanding is never a bad thing, so that you can converse, so that you can understand, you can better help your clients. So, like at the initial meeting, you want to go through here and have a basic idea of what you want to accomplish. So, to give you an idea, for those of you who don't have it in front of you, required section 3, this is litigation and transaction. We require this so that everyone has exposure to these. You need to complete 10 of these. They're interviewing a client, counseling a client, doing a complaint and a summons, attending a trial, participating in a trial, drafting, reviewing probate documents. There are a number of things you can do here. In this section only, this required section, you can take up to 4 of those off if you have completed them in a credit earning pro bono case, simulated skills course, clinical program, or externship during law school. If it didn't happen in one of those situations, you can't take it off, you'll have to do it during the program. But we leave that up to the deference of the mentor. You tell them what you did during law school, the mentor decides if it qualifies, and then it counts for that experience. Yes?
What about post-law school, but pre-program?
No. So it has to be in the program or during those specific situations. Okay. So that's the plan, and you'll go through, look at those required ones. A number of times, and it says up here, it'll say participate in, and ideally we want you to have hands-on experience in every single thing. We're also, you need to realize that life is life, and that not all of you are going to be able to participate in a jury trial. So you can observe, you can discuss those. In this order: participate, observe, and discuss. Please try as hard as you can to participate in something. If all you can do is go observe a trial, there's a lot that you can get out of just sitting in a courtroom and observing a trial. Worst case, you discuss it with your mentor. And another note on confidentiality with your mentor. A lot of you will have mentors outside your firm with whom you can't discuss particulars of a case. So, talk to your mentor about how comfortable they are with you talking about real cases, first of all. Talk in hypotheticals if you have to. And if it comes down to it, talk with your client about whether or not you can talk to this mentor and bring it in. Supreme Court Rule 14-808 is the rule that governs the NLTP. In Section H of that rule, it discusses the relationship that is developed with a mentor and in terms of confidentiality. So discuss that also with your mentor to avoid any issues. And if you have questions about it, let me know, and we can talk through that.
Question.
Yes.
What about those who were like in another state for a significant period of time? Can you count any of that experience?
Well,
Or is it no?
if you practice in another jurisdiction for more than 2 years,
Over 2 years in July.
okay.
Just a terrible timing, so.
Why don't you talk to me after and we'll talk about your specific case. Okay, this is the plan acknowledgement. And this is administratively for me to make sure you and your mentor have met to begin the program. It's more for you so that you know what you're going to be doing during the year, but also to write down the goals that you're going to have and how that plan is going to work into fulfilling those goals. And that's what's due on August 4th. You can email that to me. The only thing that I need in a hard copy is the completion certification at the end of the program. Anything else can be emailed. Okay, you have this in your manual. So, this is how we monitor it. There are 2 status reports during the year. They're to reassess the plan, to talk about your goals, and to assess the relationship. And again, it's an administrative thing for me to make sure that you and your mentor are meeting when there are problems, but it's more for you and your mentor to kind of gauge where you are. And the forms are in the manual. They're also all online. I also send out a reminder with them attached. So you have significant access to that. And again, please put in your calendar long before the due date that they are due, so that I don't get those calls on the date that they're due. And then the completion certification, this is at the very end of the program, and your mentor is the only one that signs it, and it certifies that you completed the program. And when that is submitted to me, that is when you and your mentor get your CLE credit. And that's the only thing that cannot be emailed. Now, the fees for this program, they cover the administrative fees and the CLE credits that you get for this program. And I'm going to have the director of the mandatory continuing legal education come in a minute to talk about compliance and things like that. But this program takes care of half of your CLE credit for the first compliance cycle. So the fees you're paying cover that. Half of those fees were paid already. The other half, the 150, is due on completion. You now have a year's notice that that fee is due next June. Okay? So I know money gets tight. I totally understand that. If you save $10 a month between now and then, you'll have it. If there's a huge problem, then let me know, and we'll figure it out. The website is off the Utah Bar website, the mentor program. All of the forms, the calendar, old newsletters, a blog that I have great ambitions of starting, and resources are on here. Every month you'll get a newsletter from me. It'll have articles that are relevant to the program, and on the left-hand side we'll have dates as well coming up. Just to wrap this really fast overview up, the program is 12 months, so if you finish it in 2, congratulations, but you still have to meet for 10 more months and figure out more stuff to do with your mentor. So it is not meant to be crammed into 2 months. Like I said, if you want to do all 20 elective sections and more, go for it. But it has to be 12 months. You can change your mentors once during the program without any questions asked. If you change more than that, I'm going to want to know why. We talked about the activities in law school. Your bar account, all of you pay your licensing fees online. Please remember that username and password, because that's how you interface with the bar, and you can get updates on your CLE credit and register for other events. When you submit things to me, please submit them as a PDF, not a JPEG, not as some random rich text document. I keep everything online in online files, and it is selfishly easier for me if they are submitted in PDF format. And then the deadlines, once again, please plan for those deadlines. Judge Tim talked about this. You're not anonymous in this profession, so take ownership of it and use this year with your mentor to determine the type of lawyer that you want to be, and find opportunities to become a professional and an ethical lawyer, and to discuss those situations that can arise that are that will boost your ethical credibility and your professional reputation. If you come up in one of those elective sections and your mentor is not comfortable talking about it because they don't know that area of law and they don't want to learn that area of law with you, you can bring in another mentor just for that area, and they'll get an hour of CLE credit for that if you tell me that they would help to. So that is an option. My contact information, but you hear from me so much. If you don't hear from me in the next 2 months, then it means I have a problem with your email address, because I really like to receive emails. So if you're not hearing from me, there's a problem. You should probably reach out to me. Any questions? Okay. As you go through this, if you and or your mentor have questions, please contact me. Okay? Okay. So Susie Curry is the director of the Utah State Board of Teaching and Legal Education. I put her contact information up here. She's just going to talk to you a little bit about. Let me see. Hi, this is Susie Curry. I'm the director of CLE.
You won't hear from me a whole lot until the end of the CLE compliance cycle, other than, I just want to quickly just go over what the rules and regulations are for new lawyers. It's a 3-part program for the new lawyers. The first is the 3-hour mandatory ethics program. And first, I want to back up that I assume that after talking to Emily, most of you were admitted in either October 16 or February 2017. And with that being said, the MCLE rules require that new lawyers receive 2 complete June 30th reporting periods. So that puts your first reporting period at June 30th of 2019. So it gives you a little additional time to get from whenever you were admitted until June 30th of 2019 to complete the 3-part program. As the first is the mandatory new lawyer ethics program, which is given after each admission ceremony, generally in the spring and then again in the fall. I don't have the specific dates, I don't know if you do, but that's still down the road. That's a 3-hour program generally, and you only need to attend that program once. So that's a great program. Secondly is the program that Emily's been talking about, the new lawyer mentoring program. The next program starts in July, and then there's one again that starts in January. We have had problems with people being suspended because they've not taken that seriously, not taking the first available 12-month program. So you should take it as soon as you can to get that taken care of, not wait until it's too late, because they're having problems. We have suspended lawyers before for that. So once you complete that program, you receive the 12 hours, and your mentor receives the 12 hours. Once that 12 months is complete, and your mentor signs off on that. The final requirement is the 12 hours of general CLE. Those can be live or self-study. But any type of CLE, if you want, the bar has a great myriad of new lawyer programs or nuts and bolts programs that are always helpful. Those can be done in-state, out-of-state, just any type of CLE. One of the questions that the MCLE office always hears is, the requirement is 24 hours. Why do new lawyers have to complete 27? The new lawyers is a 3-part program. It's the mandatory, it's the new lawyer ethics program, 12 hours of general CLE, and the 12-hour new lawyer training program. So it is a little bit more for the new lawyers, but it's still in the course requirements that it's that the new lawyers have to complete the 3-part program, which ends at 27 hours. I want to talk a little about compliance. When hours are due by June 30th of 2019, the hours are completed after that date. There is only a $15 filing fee when you complete the hours and file by June 30th. If you wait until you complete the hours into July, there's a late fee. You do suspend lawyers, you file a petition with the Supreme Court, and you suspend just a small amount. It ends up being, a little sticky. Your reinstatement always happens every single year. And it's suspending about 150 lawyers every year. So that does happen. The reinstatement is always tricky and embarrassing a little bit for attorneys, but it does happen. It's never a fun thing to go through. For the full, just the 24 hours, it's just every 2-year period. So once you complete the new lawyer's seal in 2019, following that, it's just going to be 24 hours every 2 years. 12 need to be live in person and 12 need to be self-study. Those hours can be completed in any jurisdiction after the first new lawyer requirement takes place. Again, CLEs every 2 years. You're going to be odd year CLE compliance lawyers as long as you stay active moving forward. And then licensing is annual, so just make sure that you remember that. This is the first year that those who are applying on the odd year will be able to file online. So for those who activate, this won't be your group, for those who pay online this year, it's going to, once they pay their barges, it's going to comment or trigger them to pay their, go on and do their CLE compliance on 100 hours. So we're going to go over that. Anyway, if you have questions, yes?
Yeah, 2 questions. The first is this 27 hours for us now, 24 hours subsequently. That's every 2 years, right?
Correct. And you'll have additional hours, or additional time to complete that.
Right, we have till 2019.
Correct.
Can you bank hours? I expect to have more than that. Can you bank hours, or is it a strict cutoff from that June 30th date?
It'll cut off June 30th, 2019, and start fresh July 19. There's no carryover.
And there are a few of you in here who actually complied in 2018 because I tracked you. So the majority of you were in 2019, but if you were admitted in 2015, then you'll comply next year. If you're confused, you can call one of us and get your compliance date.
The database and how much we do that. We work really close together, so we're close to directors, so. Yes?
So the 12 hours we have to do in addition to this program and then the professionalism bit?
No, you don't. That, the professionalism hours, the only thing you worry about is your ethics program takes care of the specialized hours.
There's like an additional 12 hours, correct?
A general CLE, any type of CLE.
Does it matter if that's live?
No, live or self-study. Yes?
And any CLE hours you've already done after taking our oath will count up till now as well?
Absolutely.
Okay.
You can go online with your password and get in track the records. And if there's hours that we don't have, call us. If you take another jurisdiction, we're happy to help you get those accredited. Sponsors have 30 days after the program to report the hours if they've been accredited. So sometimes there's a little bit of a lag time, but we're usually pretty good about getting those hours entered in the system. Yes?
I'm sorry, can you explain that a little more? So if I'm admitted in 2 states, I do CLEs here, what county that it, can I use?
As long as it's traditional CLE, most states don't have a problem getting those, or accepting those hours. Getting those accredited sometimes takes a little more effort on the work part. If it's a national provider, ask them to apply another jurisdiction. We're usually happy to. We have a form on our site you can use to apply if you take a program in another state. The sponsor won't apply for you. We've got forms on our site for you to use. Form 4 is for live in-person program, and Form 5 would be for webcasts or self-study programs. So my contact information is here. I'm just behind the receptionist desk. If you have questions, there's 3 or 4 is the CLE office. So feel free to time. I'll have any questions. Thank you.
Apparently I don't get a slide. Thanks, Emily.
Next time.
All right, I'm sure everybody is really excited to be here. I'm last, so you've got maybe 5 minutes left, don't worry. You know, I've got this whole spiel I can give, it's inspiring and talks, it's very moralistic. They can talk to you about how pro bono work is the most important thing you can do in your legal career. But instead, I'm going to do a more selfish spiel that talks directly to you and says, here's how you can get through the new lawyer training program by doing pro bono work, and you can get it done extremely quickly. So I could actually look at, let's see, 3 people in this room that came to a pro bono program within the last month. And they came to our West Jordan landlord-tenant calendar. And what that is you come for 2 hours and you help out a tenant who's being evicted. And you help them by representing them at that hearing. So you come in, you interview that client, you counsel that client, you negotiate with the other side, and you appear in court. So that's 4 parts of the NLTP program that you get done in about 2 hours, and parts that a lot of people aren't going to have the opportunity to do at a big law firm if you're working for a big firm. Or even a medium-sized firm that's not going to let you have that kind of hands-on experience that quickly. So when you're looking at the NLTP program and you're thinking to yourself, how do I get this done as fast as I possibly can? How do I get this done in a way that I'm actually interacting with real clients and learning real legal skills and not just sitting at my desk and looking up things on Westlaw all day? What you can do is you can talk to me. My name's Tyler Needham. I work here at the bar. And if you want to do some pro bono work, get in touch with me. We have a modest means program as well, where attorneys will charge discounted rates for people to qualify. Most of the people in Utah can't afford to spend $300 an hour on an attorney. I don't think almost any of us in this room could afford to hire ourselves if we had to go out and find an attorney. So what the modest means program does is attorneys agree, yeah, I'll charge a reduced rate in order to accommodate somebody who can pay for an attorney, but they can't pay full price. So a family of 4 that makes $30,000 or $40,000 a year. So we've got that in addition to pro bono opportunities. So all I'm asking you to do is if you're thinking, how can I get through the NLTP program? How can I learn valuable legal skills that then I can show to my employer? When my employer comes to me and says, hey, can you do a deposition for this case? You'll say, oh yeah, I've already done one because I did it on my pro bono case. Or when they come to you and ask you, okay, we need you to go in and negotiate with this client, you're going to have the experience. You're going to have gone to court before because you took on a pro bono case and you understand how to actually be an attorney. And that's really important. So if you're thinking about doing your LTP program, talk to Emily or talk to myself. We're going to send out a link right after this that talks about all the different pro bono opportunities in Utah, regardless of where you are. We have pro bono everywhere in the state, and people desperately need that help. So if you are interested, does anybody have any questions right now? All right, you're free to go. Thanks.